I have no idea. John had another key, Jay had, I never even looked at it on the phone, so I didn't know.
Oh, things that we gave you.
Oh, I give it to Jay.
Oh, oh.
No, I know, I mean, I get it, that's one of those things, you know, so, yeah, yeah.
That's exactly.
Yeah, so I'm thinking that actually.
Yeah. This one's French. See, this is yeah. Oh, yeah. Yeah, I saw that.
No. What was wrong with it? I mean, I was really, just to bring it up, yeah.
let's go ahead and bring in those next two jurors, and then we will give instructions to the remaining ones. Should be 92 next.
Yes, sir.
Number 26. Oh, you can put your first your things in the chair. You can just come right there. They set up. Just stand right there. No, you have to stand. Go ahead, Mr. James.
Yes, sir. 92. You indicated. I see that you were formed an opinion juror on a murder case before.
Yes.
Yes, sir.
Okay, and you tell us what that opinion is. What county was
Based
that
on
in?
what I've read, I
Layton
believe
County?
that she was
How
having
long
an
ago was
affair,
that?
Amy,
10, 15 years ago.
perhaps influenced, and then
Now, without telling me what the verdict was, were you all able to reach a verdict? Now, you do understand that in a trial, if you're selected as a
I
juror,
also see that
you're going to have to sit here and
been exposed to some media coverage
and make a
Right.
decision
about this case,
independent of
and
anything that you
specifically I
have
want to
read
ask
or
her about
heard.
your
But just based on what's
responses.
in front of you, if the court instructs you that you're to set aside any of that stuff, what you may have read or what you may have heard, to make a decision just based on the facts and the evidence, are you able to do that?
I could try.
You could try. And I'm not badgering you, let's be as specific as possible. When you say you could try, are you saying that you could or that you could not?
I believe I could.
You believe you could? No further questions at this point, Judge.
Mr. Petrie?
Thank you, Your Honor. Sir, before I get to, I guess, some of the questions actually regarding this case and your qualification, you indicated that you have a trip planned that starts tomorrow
Yes, sir.
to the West Coast
Yes, sir.
with your mother.
Yes, sir. And my
Driving
family.
or flying?
Flying.
Have you already bought the tickets?
Yes, I have a copy. I sent it in, but I also have a copy of my plane ticket.
Okay, and I assume, I don't make the words, these are non-refundable tickets, they're not ones where you pay extra for
Right.
and can
Yes, sir.
exchange. You'd lose money if you don't go.
Oh, I'm losing money now, but yes, sir. I
Oh, no,
would.
but you lose
Yes,
money
on that.
on tickets.
Yes, on the tickets.
Depending on the airline, it's like, usually like $100 a ticket if you don't go, something like that for a change.
I think that, yeah, I mean, and then the difference in the fares.
And the number of people involved in this trip, I know you said you and your family and your mother. Your
Right.
family is how many other people?
There will be two other people in my family, my wife and my daughter.
If you're going on that trip, when would you return?
Sunday?
This coming Sunday?
Yes, sir.
Okay. So if the trial actually started next week, you'd be, as far as this trip is concerned,
As far as that trip is concerned, that would correct. I would be
Okay.
back Sunday.
but
evening.
insofar as, excuse me, I interrupted you.
As far as that trip concerned, yes, I have other issues, but yes, as far as that trip's concerned,
But if there's further jury or potential jury involvement this week, that trip would conflict with that, if it's
Yes.
Monday through Friday of this week.
yes.
Okay. You indicated in your questionnaire, in addition to the questions about the conflicts, you said, also, I think she is guilty. You also indicated that you are probably prejudiced against poor and minorities to some degree. Is that correct?
No, that's not, shouldn't be my questionnaire.
Well, they put it in here. I beg your pardon. You feel that it says it looks like prejudice, but I believe that word is actually prejudicial. You feel that the system may be prejudicial toward?
Yes.
Okay. I'm seeing you in a completely different light now, sir, and I do apologize. Your writing is not a whole lot better than mine, but it does say
Apologize.
prejudicial. You indicated that you are aware that most of the serious charges, dash murder, etc., were dropped.
Correct.
So you are aware that there were other charges in this case other than the ones that we will be trying here next week.
Yes.
And again, this isn't a test. There's no right answer. There's no wrong answer. As long as a juror gives us his or her honest answer, then that is the right answer.
Okay.
Do you believe that your knowledge about some of the past history, either historically or procedurally in this case, would affect your ability to give Mrs. Sneiderman a fair trial only for the offenses that she stands charged with today?
I think she had an affair with Henny Newman, and how that would influence the fact that she said she didn't, or whatever the other charges were. I mean, he asked me if I could put that aside and listen to the facts only, and I said I think I could. So I guess it's a similar answer. I mean, I've heard that. I thought that there was guilt there, but I haven't gone. I haven't heard all the facts. So
That was going to be part of my next area of question. The jury that's ultimately chosen in this case to decide Mrs. Sneiderman's guilt or innocence is going to essentially be doing two things. Number one, it's taking the evidence that is either testimony or documentary evidence, physical evidence, however it comes in, that comes into this courtroom and nowhere else, and the judge, I anticipate, is going to be telling the jury, here's the evidence in the case. Now I, Judge Adams, is going to tell you what the applicable law is, what the rules are, what your duty as a juror is. You take the one and apply it to the other, and that's what you look at, that's what you consider to determine whether or not the defendant is guilty.
right.
Could you in fact do that? And that is actually asking you to take your previous opinion that she is guilty, and to take your previous opinion that she had an affair, and completely ignore those and base your decision solely on what happens in this courtroom.
I said before, I think I could. I think I could try. I don't know. I can't predict the future, but
Do you believe that your prior opinions about this case, as you're trying to set them aside, do you believe that they would serve as an impediment to your ability to look at the evidence and make a decision based on what happens here in the courtroom? Would they? Do you think there is a likelihood that they could influence you?
they could influence me.
Your reservations about the fact that they could influence you, I guess I'm a little bit conflicted. You told Mr. James that yes, you would try to, and you believe you could follow your oath as a juror. And the oath as a juror is to base the decision on what happens here in the courtroom and take the law that the court gives you. Is the conflict that I hear coming from you about what you know already, what you think already, what your opinion is already, versus what the law was going to require the jury to do in here, is that of serious enough concern to you that you can't tell us here today that you can give Mrs. Sneiderman and the state both the fairest trial that you can possibly give?
I'm not exactly sure how to answer that, other than I don't know how I will feel how I will react in the future to something that I haven't gone through yet. So I think I could try. I think I could, but I mean, something in the back of my head. I mean, I don't know. I don't know.
Okay. Now, you also indicated, sir, in your questionnaire that if you are actually selected to serve in this jury, you said an absence of several weeks, and we do believe that the evidence portion of the trial will take approximately 3 weeks, maybe a little bit less, but that's what, in good faith, both sides agree we're looking at. You indicated that would cause your company to cease, and it looks like you've underlined cease twice, cease operation. It's a 3-person firm. You indicated one of the persons at your firm is purely administrative. Tell us about that, please, sir.
Yeah, I've worked on, built this company up for, since 15 years or however long, since '99. I'm the senior person, the person that built the company. I do most of the work. I deal with the clients. I write the proposals. If I'm not there for an extended period of time, the company will cease to exist because I'm not there to do what needs to be done to keep it going. And in fact, when I'm scheduled right now, the day after I get back, to be in Florida for a whole week doing a mussel relocation survey in the Chipola River. And I mean, that's been planned as well. And if I don't do that, then I'm fired off that job and I'll never get that money back, and I'll lose additional monies related to any future work. So it's...
Is it safe to say then that serving 3 weeks as a juror in this case would serve as a severe financial hardship, not only on lost monies during this period of time, but the potential for lost contracts in the future?
Oh, absolutely. There's no doubt about it. And then there's other people that I work with, they're out of it.
Okay, thank you, sir.
Thank you. If you could just follow the instructions of the clerk and give them some instructions back there. Mr. James?
Your Honor, I believe this juror is qualified. Point to question number 39, where it says, do you for any reason believe you cannot be true to your oath as a juror? The response was, I believe she is guilty. However, I would promise to try and be fair and objective. I asked him that question when I was talking with him, and his response was the same as was in his questionnaire. That he would try to be fair and objective. What he essentially told Mr. Petrie was that he could not speculate as to how he would decide in the future, but the only thing he could tell him now, as the facts stand, that he would try to set what he knows about the trial, what he knows about the prior case, and anything with the defendant aside, and listen to the court's instruction, and be a fair and impartial juror to the best of his ability. And I think that meets the standard, Your Honor.
Ms. Petrie?
Your Honor, I would move to strike the juror for two purposes. Number one, due to his previously announced bias and prejudice against Mrs. Sneiderman, he hinted around how he thought he would try to do his best to be fair, but he indicated that he is biased against her. He believes she is guilty. He believes she had an affair, and I believe that his previously such strong statements that he made before, Your Honor, are certainly stronger than the tentative answers that he gave here today. Also, Your Honor, I believe that this juror should be excused for a hardship. He is half of a two-person firm, if you don't count the administrative person who does none of the field work. He says that there's a very good likelihood that his business will cease to exist and he will lose future money. It will be a huge financial hardship if he serves in this jury for 3 weeks. I believe out of deference to what we've done with other jurors as well, I would move to excuse him for that purpose as well.
All right, lawyers, for the purpose of this, I'm gonna let him go for a hardship. I'm gonna let him go for cause. Could you bring in 95? Yes, ma'am.
Juror number 95, I see that you have been exposed to some media coverage surrounding the case. If you could explain what you've heard and what you've seen.
Just what's on the news in regards to the beginning of the case, or
Just
what?
this case in general.
This case in general?
Yes,
Just
sir.
what Andrea is accused of?
Okay, that's all you've heard on the news?
Yeah.
Okay, what about the previous case? Did you hear anything about that?
Yeah.
Okay, tell me what you heard about that.
The shooting and the following conviction.
Did you follow the case very closely?
No.
Okay. Question number 51, I'm going to quote your responses. There are truths to this case that has not been discovered. That's what you wrote. Can you explain what you meant by that?
I believe it's just accusing, and I don't know any of the evidence that's in the case. So until someone brings out the evidence, there's no truth. So I think that there's stuff that is just, that has not been discovered.
So, in other words, what you're telling me is that you're not making a decision until you hear facts or evidence?
That's right.
All right. I also have an indication that you or someone close to you has been affected by divorce, is that correct?
That's true.
Okay, can you explain that to us?
My mother and father divorced when I was young.
Was it, well, first of all, how old were you?
7 or 8.
All right. Were you old enough to remember whether or not it was contentious?
It was, yes.
Okay. Is there anything about this case or this happened today or anything that you've heard in the media that would prevent you from being a fair and impartial juror?
No.
All right. Thank you.
Mr. Moyer,
Yes, sir, just a few follow-up questions.
you may.
Sure, number 95 is obviously showing my ignorance. What is an iOS device?
iPhones, iPads.
Okay, so you repair iPhones, iPads, and troubleshoot those?
That's right.
Okay. You leave your business card.
I'll leave a number, you can call me.
Also, there was a question, I just got to ask this. Question number 5, it asks racial or ethnic group. Let me just say that is important in some of the legal things that go on. And you write 2 or more. I think all of us are 2 or more.
That's right.
And so what do you,
My mother's white, my father's black.
okay. And you see no reason at all that you are not able to serve as a juror on this case, is that correct?
As long as it doesn't start tomorrow.
We all wish. Thank you, sir.
I just follow the instructions of the clerk. Please. What state's position?
Objection, Judge.
No objection, Judge.
You qualified. All right, lawyers, approach momentarily. Let's get this correct. You can bring them in? Yeah, just come on in, go all the way down, because everyone can have a seat. It should be about 15 minutes. Come on in. Go all the way down. You can be seated as you come in. I was going to give you some instructions. Come on in. Just come on in, go all the way down. Come on in. Everyone should have a seat. Now go to the second row. Everyone come on in, have a seat, take your time. No rush. Counted correctly, everyone should have a seat. One short, I didn't count correctly, so it's 16. Okay. That's fine. Let her have that there. That's fine, we're gonna get rid of that, actually. All right, ladies and gentlemen, we are still in the process of questioning because I'm trying to release you in a reasonable time so that you may have child care issues, you may take care of parents at a reasonable time and actually stay a little later than anticipated. You still have to be subject to individual questioning, so what I need to do, I need to stop for tonight and bring this group of potential jurors back tomorrow morning at 9 o'clock a.m. so we can resume with the individual questioning. This is a lengthy process, and I thank you in advance for your patience. Let me give you these instructions before I release you for the evening, and I'll have a separate set of instructions for the remaining jurors. When I release you for the evening, and you're going to do, you'll be able to take those numbers off with you, new numbers in the morning. Do not discuss the case. I allow anyone to discuss the case with you. Once I release you for the evening, do not remain upon the floor, because I don't want you to hear anything you should not hear. Do not read or look at any media coverage pertaining to this case. Do not go upon the internet and do any research about this case. Do not blog about this case while it's ongoing. Do not grant any interviews to any possible media individual. Do not go to any location that may or may not have been discussed. All the evidence will come to you in the form of sworn testimony from this witness stand and any physical evidence that is introduced during the course of the trial. You're more than welcome to bring something to snack and or with you during tomorrow and during the breaks, during the lunch breaks, and do not consume any alcoholic beverages during lunch, and do not overindulge tonight. You're more than welcome to check your messages and all those things, but make sure if you can't, not if you can, but do not do any research about this case. It did not allow anyone to communicate with you anything about this case whatsoever. The lawyers and the parties cannot talk or interact with you. I don't ever want you to think they're being rude or discourteous, but they can't talk or interact with you. Now, you've been given some instructions. I need you to assemble back in the same location where you met this morning at 8:30 tomorrow morning. 8:30 tomorrow morning, and then we're going to resume this process. All right? Any questions about logistics? All right? And the parking code that you have received, that'll be good for tomorrow also. When I say any questions about logistics, let me do this. I'd like to give another group of individuals some additional instructions. If you have some additional questions about logistics, you can write it down. Jay will give you a pad, and she will bring that out to me, and I will share that with the lawyers. I will give you a response. But with the exception of those individuals, now, no one is released. Let me make, I can't stress that. No one's released. This is an ongoing process, all right? It is currently 5:40 p.m., and most of you have been in this building probably since about 8:30 or 8:15 this morning. So I'm trying to factor in that you may have something to do tonight, okay? Follow the instructions of Jay, and she will talk to you in the hallway, and before you bring the next group, let me see what these questions are, okay?
Okay.
All right,
Yes, sir.
just follow Jay, who's with jury management at this point in time. Thank you for your cooperation. I'll be here, but that's only for you.
Okay.
Thank you very much. See you tomorrow. See you tomorrow morning. see those instructions. Make sure you get one out too, make any objection you want to make.
None from the state.
None from the defense.
All right.